Welcome to the Slop Docket, where we cut through the AI hype, one fabricated case citation at a time. I'm your host, and I'm a law librarian, which means I help people find the law, real law that actually exists. So you can imagine how personally I'm taking what's happening right now in American courtrooms. Let's set the scene. In 2025, AI is everywhere. It's drafting emails, writing code, generating poetry, and apparently inventing court opinions that have never existed. Attorneys are submitting these invented opinions to judges. Judges are reading them. Opposing counsel is researching them, and nobody can find them because they aren't real. This is not a hypothetical. This is not a rare glitch. This is a systemic crisis unfolding in the American legal system right now. By the end of 2025, nearly 400 federal court rulings had addressed AI hallucinations in legal filings. 400. And here's the kicker. The pace isn't slowing down. In the second half of 2025 alone, 285 federal cases involving AI misuse hit the dockets. And that's not a seep, that's a flood, an AI tsunami of slop. And as 2026 ends its first quarter, we're at 226 federal court filings. Now, what exactly is slop? It's not my word, though I've adopted it with some enthusiasm. The Cambridge Dictionary added it in 2025 to describe AI-generated content that is low quality, the kind of output a large language model produces when it's pattern matching its way through your legal brief instead of, knowing things. The AI output has been described as acceptable but subpar. Here's the fundamental problem with large language models, and I need you to really hear this. They do not know things. They predict things. When you ask ChatGPT to find a case supporting your argument, it doesn't search a legal database. It generates text that sounds like a case citation. It predicts what a real case citation would look like, and it produces that confidently with the judge's name attached, with the volume number, with the page number, all fake. This is what the field calls a hallucination. And in the legal profession, hallucinations have consequences. My forthcoming article, The Slop Docket, Gen AI's War on Legal Truth, documents this evolution in detail. And that research anchors every episode of this mini CEL-styled series. What started as an isolated incident has metastasized into something that Chief Justice John Roberts himself compelled to address in his annual report on the judiciary 2023. Here's what I find particularly striking about this crisis. It's not just about bad technology. It's about what happens when professionals stop verifying their work. The legal profession has a word for this. Actually, it has a rule for this. Federal Rule of Civil Procedure 11. You sign a document, you're certifying it's accurate, you're certifying those cases exist. Attorneys are signing documents without checking whether the cases they're citing are real. One court put it bluntly, fabricating legal authority is a serious misconduct. Another observed, and I'm paraphrasing here, that sanctions for AI misuse have become so modest and so routine that they are, quote, insufficient deterrents. Attorneys keep submitting fake citations. Courts keep finding them. The cycle continues. Now, I want to be fair to technology for exactly one moment, because I believe in intellectual honesty even when it's inconvenient. AI tools can be genuinely useful in legal practice. Document review, preliminary research, drafting routine correspondence. Westlaw and Lexis have both integrated AI into their platforms. These platforms are specifically designed with legal data sets and retrieval augmented generation. They don't eliminate hallucinations, but they're better than asking general purpose chatbots to perform certain legal tasks like research. The problem isn't that lawyers are using AI. The problem is lawyers are using AI as if it were a verified database with real cases. and they are not checking the output. They are treating the confident, fluent, beautifully formatted text of an AI response as research. It is not research. It is autocomplete with a law degree aesthetic. There's a philosophical dimension to this that I find genuinely alarming, and I don't use that word lightly. The political philosopher Hannah Arendt wrote about what happens when a society loses its shared factual world, when constant misinformation makes distinguishing truth from falsehood nearly impossible, when nobody can agree on what's real. Democratic institutions lose their foundation. She identified that epistemic breakdown as the precondition for authoritarianism. Now, I'm a law librarian, not a political theorist, but when courts must spend their limited resources verifying whether cited cases exist before they can even begin to evaluate whether those cases support the argument, something has gone badly wrong. The legal system runs on shared factual reality. Citations must refer to real things. Precedents must mean something. When they don't, when any brief might be fiction dressed up in proper blue book format, we are in genuinely dangerous territory. This is not adolescence. This is institutional rot, and it requires an urgent response. So here's what I'm doing on the Slop Docket. Every episode, I'm reviewing the cases, the ones that slipped into the slop. I'll examine what happened, what the court said, what the sanctions were, and what it tells us about where this crisis is headed. It's going to be sharp, it will be honest, and occasionally it will be furious because some of this is genuinely infuriating. Once in a while, it will be funny as a Kafkaesque absurdity can be. Next episode, we start at the beginning, the case that launched numerous standing orders, the moment the legal profession got its formal warning, and spoiler alert, largely ignored. Mata versus Avianca, a personal injury case, pair of attorneys, ChatGPT, and 6 judicial opinions that did not exist. What could go wrong? I'll also look at what may be the very first AI hallucination case in American legal history, a pro se litigant in Maine, a foreclosure dispute, and a court that had to explain, for perhaps the first time on record, that blind reliance on artificial intelligence does not excuse misrepresentation of the law. That's Scott versus Federal National Mortgage Association, patient 0. I'm your host. This is the Slop Docket, where rigor meets reality and where we take AI-generated legal fiction exactly as seriously as it deserves, which is to say, seriously enough to document it, and not seriously enough to cite it in a federal brief. Subscribe wherever you get your podcasts. New episodes drop regularly, and if you're an attorney who just thought I should probably double-check my citations, good, go do that. We'll see you next time.